To call the meeting to order. Today is Thursday, October 10th, 2024, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino, Tongva, and Gabrielino Kizh peoples. Vice Chair Rory, would you please lead us in the Pledge of Allegiance? Thank you. Mr. Secretary, may we please have a roll call?
Commissioner Goldman?
Here.
Commissioner Kirpies?
Here.
Commissioner McCafferty?
Here.
Commissioner Paris?
Here.
Commissioner Topshin is absent tonight. Vice Chair Rory?
Here.
Chair Bass?
I'm here. We have a quorum. Thank you. Has everyone had a chance to review tonight's agenda? If so, I'll entertain a motion to approve it.
So moved.
Commissioner Paris moves. Do we have a second?
I'll second.
The Vice Chair seconds. Mr. Secretary, may we please have a roll call?
Commissioner Goldman?
Aye.
Commissioner Kirpies?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Paris?
Aye.
Vice Chair Rory?
Aye.
Chair Bass?
Aye. The motion carries. We have the minutes for, let's see, it's Thursday, September 26th in front of us. Has everyone had a chance to review it? If there are no changes, is there a motion to approve?
Move to approve.
The Vice Chair moves. Is there a second?
Second.
Commissioner Goldman seconds. And may we please have a roll call?
Commissioner Goldman?
Aye.
Commissioner Kirpies?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Paris?
Aye.
Vice Chair Rory?
Aye.
Chair Bass?
Aye. The motion carries. Item number 6 on our agenda is public comment. Do we have any speakers from the public?
No speakers at this time.
Okay. This is an opportunity to address the commission on any item within our purview that is not on the agenda for this evening, and there will be another opportunity at the end of the meeting should you choose to take that. Item number 7 is the manager's report. Mr. Kessinger, may we please have a report?
Yes, good evening, Chair, Vice Chair, Commissioners. Good to see you all. Tonight, October 10th, we'll be hearing Appeal D4869 and D4876. The October 24th meeting will be hearing D4851CD and D4831CD. There will also be a new business item for the discussion of the RSC schedule through 2025. On November 14th, we'll be hearing Appeals D4884 and D4877. On December 12th, we'll be discussing, we'll be hearing the appeals for D4916 and D4889. On December 26th, the appeals scheduled are D4804CD and D4689CD1. On January 9th, the appeals scheduled are D4750CD and D4920. And finally, on January 23rd, the appeal scheduled is D4948. That concludes the manager's report at this time.
Do any of the commissioners have questions at this time? Commissioner Kirpies?
Is there a plan for having any sort of commission, I don't know what we called them, commission retreats? Not really retreats, it was still a meeting, but I don't know what.
A study session?
Thank you, yeah, that's the word I'm looking for. Do we have any plans for that?
Not that I'm aware of, but if that's a preference of the commission, I'm certainly open to it. Mm-hmm.
Thank you. Any other questions? Please, Commissioner Paris.
Kind of a dumb question, but what makes an appeal a CD or versus not?
The CD stands for a compliance determination, so it's sort of the nature of the appeal. Mm-hmm.
Thanks.
Not a dumb question. There's a lot of lingo that we all have to learn when we first get here.
Lots of abbreviations.
Yes. I have one question, and that is we canceled a bunch of meetings over the course of the last several months, and I'm just wondering if we're on track to catch up and stay within the timeline that the code requires for us to hear appeals.
Mm-hmm. I couldn't say without looking at specific case by case, but I would say that certainly if we're able to maintain quorum, I think that will help us stay within the timeline. Yeah.
If I may.
Yes, please.
Yes, I think if we maintain the schedule that we have, sometimes we cancel during the holidays, which I think will still be okay if that happens, but we've had 1, quorum issues, and then 2, we've had to move some, and then 3, we've had 1 or 2 where we've only had 1 appeal. If we maintain having at least 2 appeals, we're on track. And so I know kind of the history of how many are in the queue from my predecessor, and we're on the higher end of that, but we're not out of that information that he's provided. So I think we're good.
Okay, thank you very much. Yes, Commissioner Krupies.
They just highlighted that, unless I have to have my glasses on, December 26th, we have a meeting? Is that currently correct?
Yes, that's correct.
So how do people feel about that?
So we got an email from our secretary about our attendance availability on those days, and I asked that we put an item on the agenda for our next meeting
Okay.
to discuss the calendar through the end of 2025, and I believe
Excellent.
that'll be part of that item.
Thank you.
Is that?
That's correct.
Okay, thank you. With that being it, we will move on to our appeals for this evening. And we have 2 appeals before the commission this evening. And I believe, Mr. Secretary, do we have both parties for D4869, the first one on our agenda?
Yes.
Okay, then we'll proceed with that. The way this works is that first we're going to hear a staff report from our legal counsel. At that point, the appellant will speak first. They will have 5 minutes to provide an oral argument. The appellant can divide their time in 2 segments. So they can divide it 4 minutes, 1 minute, 2.5, however they want to divide it. Just let us know at the beginning of your testimony. And then the respondent will speak, but they will only have 1 5-minute period. They have to use all of it at that particular, well, they don't have to use all of it, but they'll only have 1 opportunity to speak. So they'll have 5 minutes at that point in time, and then the appellant will be allowed to come back and provide rebuttal at that point in time. The commission generally has questions for people, so let us see if there are questions before you return to your seat. So when you speak, state your name, your city of residence for the record, and the appellant will state how they want to divide their time. So let's proceed now with our first appeal for 1279 North Harper, Unit 3, and the appellant here is the tenant, so Lynn LeMay. We'll wait for you to get to the mic so the people at home can hear you as well. Sure.
Chair, would you like a staff report first?
Yeah, sorry. I just
That's
read
okay.
the
Let's go
instructions.
right ahead, please.
And then I didn't find them myself. It's going to take just a moment. You're welcome to have a seat while he provides
I'll
this.
stand.
Okay.
Good evening, Commission and the public. My name is Kellen Martz. I'm the legal counsel to the Rent Stabilization Commission. This appeal is D-4869 at 1279 North Harper, number 3. In this matter, the tenant has been a tenant in this property since October of 1991. This matter concerns an application filed with the city for a maximum allowable rent, or MAR, determination, and a determination whether the landlord has retained rent in excess of that MAR. The hearing examiner in his decision found that the city's MAR showed the rent at $783.49 starting in March 1st of 2024. Hearing examiner also found that there was insufficient evidence provided in the record to determine if the tenant had paid more rent than the permitted MAR. In this case, the facts are not in dispute, so the commission is reviewing this under the de novo or independent standard of law. The undisputed and relevant facts of the MAR is $783.48. Tenant stated in their application that their rent is $780 per month, and the most recent rent was $620.71 that was paid. In the tenant's appeal, they have argued that the property has not been registered with the city, meaning the property is not in substantial compliance with the rent stabilization ordinance. The tenant argues that this failure to register means that the property owner is prevented from increasing the rent, which results in a rent overcharge and a rent repayment due back to the tenant. Staff has found that the city law is that the property needed to be re-registered if it was rented in January 1st, 1996 or after. And here, the property was rented by the tenant and they have stayed there since 1991. Therefore, the property owner was permitted to make any lawful rent increases allowed by law, and no rent overcharge occurred due to the lack of evidence. So in this case, staff recommends that the Commission affirm the hearing examiner's decision in D-4869. And as the Commission, you do have the power to affirm, deny, remand, or reverse the decision by the hearing examiner. And this concludes my report.
Thank you.
Thank you very much. And before you proceed, thank you for correcting me on the order of our business this evening.
Of course.
Do any of the commissioners have any questions for legal counsel at this time? Seeing none, now the floor is yours.
Fantastic. Thank you. Again, my name is John Ainsworth. I am also a resident at 1279 North Harper Avenue. I am also I have the power of attorney for Ms. LeMay when she had some issues, health issues that put her in the hospital for the better part of a year. And I was taking care of this case for her, trying to get the many issues that we've had with rent and rent stabilization and the decrease hearings and everything like that at 1279 North Harper.
Are you going to divide your time?
Yes, I am.
You can take
Yes.
however much you want, but the secretary will give you a notice when your time is up if you tell us how much at this point.
I think I'll just give, like 3 minutes at this point, in case somebody,
Great, thank you. Proceed.
How much time do I have left? 4:33, okay, thank you. So I want to say that Ms. LeMay, who's seated right back there, has been done a very big disservice, partly on my part, as well as the part of the Rent Stabilization Commission, because Ms. LeMay was the very first of the long line of the 10 units that are available, the 10 units that are renting in this property. 5 of us right now have rent decrease hearings that are going through through the commission. She was the first person that went through that we took to put in front of the commission and in front of a hearing examiner, I should say, to find out about the MAR determination. And it was my understanding at that time, I didn't know just how much I had to hand feed this information to the hearing examiners. In subsequent hearings, I did do so and have been very successful in my getting that information through to them. At this point right now, just yesterday, we were given a hearing decision back from one of the other tenants in the building, which proved that there was not only an increase that was illegally given, that the MAR was less than what he was been paying, but he was owed almost $10,000. And this is in the same building where we have 10 units. Presently, 5 units are in the process of waiting the determination of their hearings. So I want to apologize to Ms. LeMay because she was the very first person that I did not know exactly how to go about doing that. As I said, in subsequent ones, I have become very good at this. And I'd like to let the representative from Scott Properties know that we will be seeing him now, because this is a new representative that was not here at the last ones. We have yet to meet, although this has been going on for 7 years. Hang on. We will be seeing a lot of you. I guarantee that, because they will appeal these. They will appeal these, and we will be back here in front of you several times. The city, I think, could have done a better job with us in putting, instead of having us go to every single one of those tenants, having to go to a separate hearing examiner. This one being that did not cite in our favor. Everyone since that has been cited in our favor. If you look over the packet, I'm sure that you'll see that we've had several rent decrease hearing decisions in our favor. I have no doubt in my mind that we will.
That's a 3-minute mark.
That's a 3 minute? Okay. Can I take 1 more minute?
Of course you can.
Okay, thank you. I have no doubt in my mind that we will continue to prove that we are correct in this issue. We have spoken with John Heilman regarding the harassment that we've received under the hands of these Scott Properties, and we will prevail. It has taken several years. We're at like 7 years right now and counting, and this has still not been decided. But as this one shows, we are beginning to get successful. And as soon as I get this successful for the rest of my building, I want to let you know that I will be finding every other building that Scott Properties manages in the city of West Hollywood and letting them
You
know
please
exactly what to
direct your
do.
comments just to the commission. We have to
Sure.
maintain order.
I will let Scott Properties know that I will be going
Thank you.
to all the buildings that they manage in this area, in the city of West Hollywood, and make sure that they know their legal rights to do the exact same thing that we're doing right now. And with that, I yield. Thank you.
Thank you. How much time does he have left?
1 minute and 2 seconds.
Okay, thank you very much. Now we will have the representative from Scott, the landlord. You'll have 5 minutes to address us, and again, you cannot divide your time. Thank you. And again, your name and city of residence to start.
Yes, Daniel Monji, and I live in Los Angeles. So this has all been mainly because, for example, the building wasn't painted on the exterior, so they get a rent decrease for that. And I'm working on having the exterior painted. It's just a cosmetic thing. As far as the units itself, we take care of everything. It's just that the owner of the property doesn't feel that the exterior, it may not be the prettiest building on the block, but I mean, everything is in order with the building. So at this point, they're getting a decrease in rent for that. And at some point, they were getting other decreases in the past. When the decreases ceased, they continued to pay, or in this case, Ms. LeMay continued to pay the decreased amount after the decrease was reversed. And so once that's reversed, the city reverses it because they come back in and do an inspection and they find that the corrections were made. And so then when they're continuing to pay the decreased amount, it creates a balance at that point. And those balances have added up. And so in this case, I believe the only case here is the MAR. And so regarding the MAR, like the council for the city stated, at that time when she moved in, the MAR, the registration wasn't required. So the correct amount hasn't been paid, which created a balance, and they're protesting, or she is protesting the MAR because her account of it isn't correct. And so we have submitted all of the financials for the property, submitted every single payment that she's made with the general ledger to establish what the MAR was and what she was paying and showing that difference. So the balance that's there is the actual balance that she owes, and she continued every month to pay a lower amount because she felt that she shouldn't pay it. But we've had a forensic accountant look over the payments. We have verified that they're correct. We have sent all of the paperwork to the city. We have had everybody look over it, and it's all accurate. Nobody has been able to tell us at which point where it's not accurate. So that's pretty much all I have to. It's all in black and white. So if you review it, you'll see that it's all accurate and correct. I believe you have the packet with everything.
We do. Are you done?
Yes, I'm done.
Okay.
Yeah.
I'm not trying to rush you in any way.
No,
I
no,
wanna
no,
make
not
sure.
at all.
I believe there are commissioner questions.
Just to clarify for the record, is the landlord demanding that the tenant pay rent up to the MAR? Because in our resolution, or my understanding is that the landlord is not demanding that. You're just explaining that the payments that have been made are below the MAR, but you're not in fact asking for that difference to be paid. Is that correct?
What we're asking to be paid is whatever the balance is on the account for any of the tenants. And the balance takes into account what the actual MAR is and what we're allowed to collect. And it also takes into account any deductions that they would have been granted by the city. So if they were granted $46 off per month because during those 6 months there was painting needed to be done or this needed to be done, then we adjusted it in the system to have them not have to pay. They only had to pay basically what the city stated that they had to pay, and we've never asked them to pay anything different. And you know, as far as like the painting goes, I already started painting the inside of the hallways. It all looks beautiful. And my
Just-
next project is the outside.
I just want to keep you on the question since the painting is not before us tonight. So.
Oh, yeah. Yeah.
Commissioner McCafferty?
So this says that the MAR is 783 and 49 cents.
Right.
But the tenant's rent is 780. Is that their current rent that you're charging? Are you charging them the MAR or are you charging them 780?
Let me see. Let me go here to the actual. Well, she has, the MAR, I guess, was 783, and she has been paying every month 731 and 49 cents. And before that, she was paying 722.49. She's always been paying less than what the actual city says her MAR is.
And what does her lease say the rent, like what is her
Oh,
rent?
from 1991, her lease is going to say a different amount.
What about like, are you charging like her, so the MAR is the maximum allowable, are you charging the MAR for her rent currently?
We're, for her rent, yes, she's been charged whatever, she's been charged the MAR, yes.
Okay,
Yeah.
thank you.
Commissioner Kirpies, I think you had your hand.
Yeah, I think you've answered the question, but I just want to be very clear. You're the manager of the apartment, right? Of the building?
I'm the supervisor for the
Okay,
company.
so my question to you is, can you tell me how much the rent is that you charge for that unit currently? Forget about MAR, forget about what she pays, just tell me what you charge for rent in that unit currently.
Well, what the system will charge will be $908.19, but then there's credits that are applied based on.
So, again, I don't know how to make this even any more clear. What do you charge for that unit for rent currently, for someone to stay there? To
For her, it would be $783.
$783.
Yes.
Thank you.
Yes.
Any other commissioner questions? Before you step down, I have a question for staff that I think might come back to you, so I want to ask this. When the city says the MAR, that includes rent reductions that have been granted, is the new MAR. So let's say the price was one number, you get a rent reduction. The MAR is not the higher number, it's now the reduced number based on the rent reduction. Is that correct?
Yes, staff calculates once it goes through this process or hearing examiner, if it's $20 off for a window or something, now the MAR is $20 less in the system that the city keeps.
Okay, and when the hearing examiner, sorry for a follow-up, when the hearing examiner considers rent increases that were allowed, it's based off the MAR at the time that the rent increase goes into place. So let's say you're charged one number, you have a rent reduction that reduces it, let's do the $20 again. The increase can only be based off of the reduced rate at 20,
Yes.
the 3% or whatever it might be?
Yes, and in the process, staff gives a hearing examiner the MAR sheet, which is a fancy Excel spreadsheet that tracks all of this. So they have that when they are doing their calculations and their hearing.
Okay. It didn't turn into a question for you unless there's something you want to clarify about the MAR?
No.
Okay. With that, I see no other questions. Commissioner Goldman? Sorry.
So if they get a reduction and then they fix the issue, does the MAR then get adjusted again?
Yes, and so when we were talking about what CD means on a number, that's a compliance determination. Landlord will apply to the city and say, hey, I fixed in this case, my case, a window. City staff, hearing examiner will determine yes or no. Once they say yes or no, a notice is sent out and says, yes, you've fixed the problem. That means the rent can go back to that $20 higher amount, or no, and you have to keep it at that lower amount unless and until you fix it again, and staff determines that you've actually done so.
Thank you.
And I'm just going to follow up with that, sorry. However, if rent is raised while the amount is reduced, they can't go back and then get, let's say, the 3% on the $20 once it's restored.
Correct.
Because that would be a second rent increase within 1 year.
Correct.
Okay. Just wanted to make sure when we're talking about MAR, we were all on the same page. Thank you very much. I appreciate your time. Now, we have, by my notes, 1 minute and 2 seconds left for the representative for the tenant.
John Ainsworth, thank you very much again. Yes, I think you asked some very good questions because that is where we're at right now. With Ms. LeMay, as I said, a disservice has been done because I wasn't aware of how to go about doing this. And in subsequent ones with other tenants in the building, we have proven that the rent was done in excess, that the decreases were not taken, that the increases were put on the amounts that were the total amounts that included also the $6 pass-through, which is not supposed to be included. And again, that I proved in this other cases, which right now we've got $10,000 coming back to that tenant. And Ms. LeMay, I'm sorry, did not have that understanding at the time when I did this. I would ask that we go back, be remanded back to the hearing examiner again for a second hearing, or another hearing examiner take over this case and redo it again. I will be putting it again, no matter what the appeal ends up. If it's, we will be putting this information back up to the city again because it was presented incorrectly on my part. I know how to do this better now, and I have no doubt in my mind that we will be successful moving forward.
Thank you very much. Before you sit down, let me see if there are questions. Commissioner Kirpies?
Thank you. So I didn't learn a whole lot of information from your presentation this evening. I don't know.
Okay. Ask questions. I'm full of answers.
So I am, but I want to make sure that you limit your answers to my questions,
yes,
please, because I don't want to give you too much extra time. How much does Ms. LeMay pay currently for rent? Is it the seven? I'm going to ask some confirmation questions because the facts are already here in the evidence. I just want to make sure that they're correct. She currently pays $780 per month?
Yes. That's
She's
correct.
shaking her head no.
No, sorry.
I'm going to, we might have a mobile mic, I don't know if we do, but I want to make sure that anyone watching can, I just want to make sure that it's actually on the record. My apologies for interrupting you.
Is this mic on?
It is. You can proceed now.
I believe both the gentleman right there, Mr. Kirpies and Ms. Goldman, you have mentioned an AMAR figure of $780-some.39. Can you just glance at your paperwork and see that figure?
No, my question is how much do you pay for rent?
That amount less the $45 that we all deduct for the painting of the building and $7.99 for some tile work that's never been done inside my apartment. So that's what I pay for my rent. That amount less those two deductions.
Thank you. My other question is, you talk about, we can't allow you to introduce new evidence here, but you're not, so there doesn't seem to be any dispute over the facts. So the amount, the $783.48 minus the $45 minus the $799, that's the current rent that she pays, and that's what she just said, so that we know that that's correct. We know that, are you saying the MAR is, because what we have here is that the MAR is not correct, your claim is the MAR is not correct because she didn't re-register her unit.
Again,
that's what the appeal is about.
No, that was me appealing it incorrectly. Again, I was not aware of how best to do this. The fact is that they've done it illegal.
Thank you. I can appreciate that answer.
Yeah.
How has the hearing examiner made a mistake in this case? Given all the facts that was in front of him or her, how did they make the mistake in this case?
The rent increases that were given to Ms. LeMay, to all of us in the building, were done illegally. Rent was taken above the amount of the MAR.
But what I want to know is how the hearing examiner in this case made a mistake. Like, you know what you told the hearing examiner. You know what limited information the hearing examiner had in front of them. So where in that, looking at that limited information, where did he or she make the mistake that you feel, or did you make the mistake?
Yeah, I made the mistake of not showing them exactly where all of the rent that was given to Scott Properties was demanded of Ms. LeMay was actually the amounts that we had been given the total amount of the rent decrease given by the city.
Thank you. Yeah, we can't allow
us.
you to testify here, but I do now, I understand your argument here, and it clarifies why I'm so confused about what's here and what you're saying.
You and every other hearing examiner that I've had. I've gone through this 5 times now. It's been very difficult.
So thank you. You answered my
Sure.
question. Thank you, Chair.
Any other questions? Vice Chair?
On the narrow issue of when Ms. LeMay moved in, there's no dispute she moved in 1991, correct?
Correct,
And
yeah.
she's occupied the
The whole time.
whole time. And you don't have any argument that the statute for registration only applies to units after 1996, correct? That were rented after 1996. You're not arguing?
No, I'm not arguing that, no.
Okay.
Yeah, no, it was more of a procedural thing on my part that I was arguing this incorrectly when I first did the hearing with her. Like I said, I got better at
thank you.
subsequent ones.
Thank you. Any other questions from the commission? Commissioner Paris.
When Ms. LeMay received the adjustments, were they provided in writing outside of like the hearing determination? Did the property management provide documentation?
Yeah,
for
the
that?
city provided us with the hearing determinations, and the amounts were taken off of that based on what the city had deemed, or about what the hearing examiner had deemed was the amount allowed to be taken off of the rent.
Okay, thank you.
But the $2,600 that they demanded back from her with a 3-day quit, that was the amount totaling the amount in the past that had been given to her from the city.
Thank you.
Sure.
I don't believe there are any other questions at this time. So we appreciate your being here and providing the testimony. We'll go into deliberations now. I want to start with just a question before we open it up to questions and deliberations about, you're good. You're welcome to take your seat. From staff, when the hearing examiner determines the MAR, it is my understanding that, and I'm asking you to tell me if this is incorrect, that they do take into account the rent reductions. So when they determine that the hearing examiner determined that the MAR was $783.49, and that includes the amounts from rent reductions already taken out of that. So the tenant doesn't then take it out of that number. They take it out of that's already been decided. Is that correct?
That is correct.
Okay. And if that number, let me ask another question. If the tenant believes that that MAR is incorrect, they have the opportunity to file and argue that particular point. I know that there's a waiting period between filing and all of that, but if they think that it was calculated incorrectly, they could file for an appeal.
Yes, I think, yes, they can do that. I think also they can speak with staff and go through, the numbers. It gets tricky when there are multiple decisions that, 20 here, 40 there, 50 there, and then one gets put back. So yes, there are multiple avenues to address that issue.
Thank you. Vice Chair Rory.
Is there a waiting period that would apply for Ms. LeMay if she wanted to reapply to determine her MAR in light of this application? And if so, what is that limitation? And can the commission potentially amend that period?
Yes, so there is a standard 6-month waiting period for whatever issues were being addressed tonight for them to refile. The commission can waive that period of time. It should not, this is just more of a general statement, it shouldn't be a waiver every single time. We have a code that requires the 6-month. Obviously, you have the power to do so, but it should be used sparingly.
Is that 6-month start from the time the appeal was filed or from the final determination made by this commission?
I believe it is from the final determination.
Okay. Because if it was from the one that was filed, this was filed in February, and the 6 months would expire. That's why I asked that question. Any other questions before we start? Commissioner Krupes.
Yeah, so it sounded like the process you described earlier for when there's a determination, rent reduction determined, that goes on, and then let's say it gets secured, then the city sends a letter to both parties, or at least the tenant, and does that letter state what the rent goes back up to? Does it does it have any numbers in that letter?
I'm going to defer to staff on that, other staff.
Sorry, could you repeat the question?
So when the tenant receives their notification that the landlord has fixed, the city has determined that the fix has occurred, and the rent will return to its previous amount, when the tenant receives that letter, does it state an amount in there?
Yes. Yeah.
So does the city have that? I mean, this is a de novo hearing, right? So, like, can we ask for that last document that went to the tenant so that we know that she's been notified that it went up?
No, the evidence is what the evidence is. You're conducting the hearing based on what that evidence is, but de novo.
Okay, so do we know that those letters went out? Or can I not ask that question because it's not?
I mean, my answer to that is it's irrelevant. The MAR is the MAR, whether someone's been notified of that or not. So
I guess my problem with the MAR is that the landlord seemed very incapable of answering a basic question of how much. I mean, 3 or 4 commissioners asked to find out what the rent is, and they've had some difficulties in that. So I don't know what, I mean, that's my confusion, is that we don't know what that top number was, or what was been asked of the tenant.
yeah, I would direct people to the MAR spreadsheet in the packet, which is going to be on page, so it's my page 42. It's towards the end of your packets. History of rent adjustments. As what the MAR was at the time that this was filed.
I'm not seeing it on page 42, or I'm missing it. Anyone else?
I have it on 51.
You have it on 51?
Yeah. In the packet.
So it should have the city seal, City of West Hollywood, and it says Scott Brody on the left-hand side,
Yeah.
February 28th.
Yes.
So that is the MAR. This is the document that is kept by staff when decisions are made here or at the hearing examiner level. You'll notice action D4527CD3. That means an action was taken on that compliance determination on that date. There was a hearing decision, so that means it was at the hearing officer level. Amount of change. So this is, just a running spreadsheet of both appeals, and so anything in a bracket or a parenthesis is a negative number. Anything without it is positive. So you can see the new maximum allowable rent as of 3/1/2024 was $783.49, and then earlier in your packet, there is the ledger from the landlord, which includes 5 or 6, 10 pages of payments going up to May 1, 2024. And you'll see the amount of rent from what they have stated was paid. And so you can use that. And so while the landlord may have had difficulties answering your question specifically, I think, one, he did answer at the end that it was $783 that was being charged. And then you have also this ledger as kind of a reference point.
Does the ledger show that he's charging $783? That's what I'm so confused about. These numbers, they submitted them as evidence, and they don't explain what they mean because.
Yeah, so yeah, it is not a clean ledger, if you will. So, but you can see let me look here. So the charge amount, so this is after this was filed, but if you go to the May 1st, 2024, it says $779. Those are the charges. So that is the amount that they're being charged.
Which page are you
Mine are different than yours. So mine says 12, so I would say probably 15 or 16. It's the first page of the ledger.
Page 21, I think.
I was at the end of the ledger.
I'd like to ask a question about the history of rent adjustments with the city seal, the Scott Brody page of staff. I'm looking here, and a couple pages later, 2 pages later on page 53, we have a copy of the lease that says rent per month when it was signed was $750, and then we go to the history of rent adjustments, and if you go to 1991, there is no $750 amount on there, so it didn't start at that number, and this actually goes back further than the tenancy in this one here, so I'm wondering how we started with, if we have evidence in our packet. I know it's de novo and we're not looking at the facts necessarily, but this is a fact that's, the lease does not match the city's records. That's what I'm getting at.
I would also, note.
And if I'm misreading it, please correct me.
Are you looking at it says standard month-to-month rental agreement?
Yes.
So it also says addendum rent 800 across the top. So I leave it up to the commission to determine what that means, but.
Regardless, neither 750 or 800 is in the city's record.
That is what the lease states.
Right.
So that's what we have.
I'm just wondering how we rely on this history of rent adjustments as evidence if it doesn't match the lease. But that can be something we debate.
I would just also note on the history of rent adjustments, there are a number of rent adjustments. I don't know mathematically if those all add up, but there'll be a question of fact for the commission to deliberate on.
Thank you. Any other questions, or please, Commissioner McCafferty?
I have a question for Steph on the history of rent adjustments. So am I reading this right, that almost every year since 2018 there has been a hearing decision on this, with this tenant on this unit?
Yes, this property does have a lengthy history of hearings and rent adjustments here. I do want to focus the commission on just what is on the appeal is whether the MAR at issue and whether there was a rent overcharge. So
totally.
Yeah.
To me, it's relevant because it's, the MAR takes history into account, and it seems like the history and the backup financials are really messy, and it's really hard to sort through this, both what we've gotten from on this staff packet and from the landlord and the tenant. So just trying to sort through that.
Yeah, and as the hearing examiner found, what staff agrees with is the burden of proof is on the party appealing to make their case both when they file and then here. And so the hearing examiner in this case found that the tenant had not provided sufficient evidence to show yes or no that there had been an overcharge. Staff agrees with that assessment, and I think some of these questions bear that out.
Thank you. Are there other questions? I want to just get the questions out of the way before we start deliberations.
So just to clarify, so if I'm just looking at the hearing examiner's decision, am I correct in saying that the hearing examiner reviewed the initial lease of not 780, but the initial lease, worked forward doing the annual adjustments, and used this city spreadsheet that we're looking at to determine what deductions should be made from that, and that's how they formed their conclusion?
Yes, so the list of exhibits is what they used, which is at the end of the hearing examiner's decision.
Thank you.
Are there additional questions? If not, let's begin deliberations. Who would like to start? Vice Chair Rory.
All right, so on this one, for me, a couple things. One is, you're correct to note that there's a history. We see that in the paperwork. We heard that tonight. There's probably going to be more appeals coming, maybe maybe not, but probably. So I think as a commission tonight, we really want to focus on just the issue before us because there's a larger process in play here. So we really want to keep focused. And the appeal tonight was a pretty narrow question of, was the MAR incorrect by virtue of the fact that the unit was never registered? That's the seminal question. And the legal analysis is it wasn't required to be registered because it was rented before the statutory cutoff. So that's not the reason why the MAR is incorrect. And I think, to me, that seems like a pretty up and down legal question. It seems like it was properly decided. And so sticking just on that, my tentative is to affirm, knowing that there is potentially other opportunities for the tenant down the road to have the MAR issue specifically looked at. So in terms of the landlord's answers tonight, that's why I kind of asked, because it caught me off guard. It does sound like they are asking that the MAR get paid. And so I think if we do adopt the resolution, we probably need to just tweak the language in section 4D that says the landlord has not demanded, because clearly it sounds like the landlord is reserving their rights to demand or has demanded, and that, that issue alone, though, doesn't change my analysis because it's just the registration requirement doesn't apply here, therefore the MAR is not incorrect for that reason, and that's kind of where it all comes down for me.
Thank you, Vice Chair. Anyone like to go next? Commissioner Goldman?
So I see, based on the facts that we have in front of us, that it seems cut and dry, but then after hearing everything, it does seem like there are a lot of questions about the MAR and how that was determined. So if we adopt this resolution, would there be an opportunity to let them, like we had mentioned, waiving maybe the 6-month waiting or something, so that they could then be able to figure out what's going on from a different angle? That's where I am, yeah, I mean, if we're asked 1996 versus 1991, that's very cut and dry, but is there an opportunity? It sounds like there's more going on here that we just can't review now.
Thank you. Commissioner Kirby, I thought you were reaching for your button, but I'll call on you.
I can go ahead and go. I agree that the decision in front of us this evening is whether the hearing examiner erred in terms of their decision on the registration form. I reread the appeal form, and yeah, so on that issue, I think we do need to affirm the hearing examiner's decision. I don't know how to address the other issues. I mean, if we wanted to even address the other issues, I don't know how they would naturally, if we didn't do anything other than affirm the hearing examiner's decision. I don't know what that means for the tenant. I don't see them, I mean, the MAR is the MAR. The MAR has been determined, and we're affirming it. So I don't see any reason for making or dismissing or making exemption for the 6-month rule. I think that if the decision is that we affirm the hearing examiner's decision tonight, I think that the message that the tenant should take away from this is to get yourself caught up with the rent that's currently on the books, and then make your arguments after that if you want to have, if you want to take it back to the hearing examiner. But I would hate to see them get evicted over non-payment of rent, which is in part what this is. So I would just urge the landlord or the tenant to focus on that. And I don't see Yeah, I'll just leave it at that. I'll affirm the hearing examiner's decision.
Commissioner Cavan.
Yeah, I agree with my colleagues here that in the scope of the registration date, I would affirm. It definitely seems like there is a disconnect between what the appeal is about, what the main argument is. It seems like it's not what is in this appeal that seems to be clear to me, but I'm not clear as to what the argument is. So I'd encourage, the tenant to reflect and find out what that argument is, if one exists. And then, if we see this back again, I would encourage both parties to get really organized with those financial records, because that's what we're looking at here. Even what's provided today, like I said before, is really hard to read, not labeled right, and isn't super helpful. So those things will help, fill in those gaps. So, but like I said, I would affirm the hearing that's on the books right now.
Commissioner Paris, you have nothing to add to the deliberation? Okay. Then I will chime in here and say, the question on the application, I too, like Commissioner Kirby's, went back and actually read the appeal, and I heard the tenant's representative tonight saying that maybe he made some mistakes in the actual process, and I'm going to assume that's kind of what happened here, because the appeal to us says the hearing examiner made a mistake by not recognizing the requirement to re-register, which is a 1996 rule, but the tenant moved in 1991. So the question before us is that, and that's I heard no debate on that tonight. It's pretty straightforward. However, I do see that the city's history of rent adjustments show that there was a vacancy in June of 1990. This is on page 51 of our packets, and that the rent just continued to increase after that point. But then there is a rental agreement on the next page that shows that rent is either $750 or $800, but around October of 1991. But the city's showing that the rent was $760.44 on September 1st, 1991. I don't know what's true in that or not, and I think that's something that a hearing examiner in finding a fact has to rectify, and clearly missed in this case. Had I heard any support from my colleagues for remand, I might have considered that. Not hearing that, the question before us is the 1991 versus 1996 question. That's really straightforward, and that moves me to affirm. One other thing I want to point out is I'm looking at the hearing examiner's decision. This is page 46 in our packets, and it says, due to the denial, the tenant will not be allowed to bring a new hearing application on these issues until 6 months after the date of this decision, which is December 6, 2024. So that's less than 2 months away. So I didn't hear a lot of appetite for waiving the 6 months, but if we're doing that, we're only waiving 2 months. I hear legal counsel's advice that we should use that sparingly, but when I see such discrepancy between evidence that the hearing examiner looked at and not addressing the discrepancies, I see that the hearing examiner clearly made a mistake in calculating the MAR, and he didn't address it. Is it 760, or is it 800, is it 750? He should have addressed that question as to where the starting point was. So I personally would like a motion that would allow us to waive and allow them to file a new hearing as of tomorrow when business opens.
Chair.
So, yes.
I just want to note, the hearing examiner, when he wrote that, doesn't take into account that there might be an appeal, so he's just writing off of his decision. The regulations are based off the most recent final decision in the case, which would be tonight.
Which would be tonight.
So it would be 6 months.
6 months from today?
Yep.
Okay. Thank you for that clarification. I wouldn't have known that, clearly. But I would support waiving the 6 month, because I think that the hearing examiner erred in the initial number, which then affects all the numbers after that. Please.
Yeah, I think that because I think none of us understand this list in front of us, and I'm only making assumptions, but if you could maybe give us how this list is used, because prior to 1995, the city would have automatically calculated an additional annual increase because the city used to set the rent prior to 1995 or at some point during that time. So the way I see this, and I don't know if this is true or not, maybe you can help us. The way I see this is the city's internal document. They've scribed along every year, gone up the percentages they're supposed to. This second column, they've made the changes. I guess that's just the value, I guess. But this is the MAR, meaning that as long as, like in 1991, there was probably a set amount, maximum that the city had for that rental unit that the landlord could not have gone over. It doesn't mean that they had to charge that amount, but they could have charged $750 if that's what I don't know what her lease said, but that's why we always have that's why our code says you go by what was demanded upon the initial, so that would be, this would be irrelevant under our code in terms of determining the MAR. This just helps the city keep track of mostly at this point in time, since we're post-1995, at this point in time, it's just mostly helping the city keep track of those $5 deductions, the $25 deduction when it goes back and forth. Is that how this list is used?
Yeah, that's correct. I think you make a good point that if the MAR were lower than the amount on the lease, then we would have a problem because that would represent a violation. But certainly the landlord is welcome to charge less than the MAR because it represents the maximum amount. As you can see here, in more recent years, it's often used to track hearing decisions. So it's part of our rent registry, and it's used to sort of track these reductions to the MAR and make sure we have that clearly laid out in the system.
I think it's illuminating, and I appreciate the history because it's something that I've just learned as you've been talking. That being said, the hearing examiner in their decision does not really show how they came to that number, and if these are the documents we're relying on, I find that there's some discrepancy, which is why I would like, I was predisposed to remand, but I'm open to voting to affirm with the waiver if there is or I can just vote against the rest of the commission. So let's see where my motion goes here, but that's where I stand. As I'm clearly in the minority, I'm not making the motion, so I'll lean on somebody else.
I would support waiving and allowing them to file. I'm waiving the 6 months.
Josh, where are you on the waiver of the 6 months? Because I heard you, I kind of understood you say you were leaning towards not waiving, and I'm really on the fence, and kind of maybe leaning towards not waiving either, because I want to give deference to the hearing examiner on how they did the MAR, and I'm not clear that there was a mistake that was made with the MAR, so I'm just curious. I think on that issue, that's the only thing maybe you take a straw poll before you do your motion.
I think a straw poll is in order, so I'm clearly in favor of waiving. I believe
I'm in favor of waiving.
No, but I mean, I would, but no.
I'm in favor of waiving.
That's 4, so. Would somebody like to attempt a motion to that effect?
But I think she just did. Was made a motion?
Yeah, I would like to motion to waive.
I'll second.
I would suggest making a motion to approve the resolution with an amendment that the 6 month is waived. That would be my suggested.
Yes.
And just for the public, I apologize if that's mansplaining. I don't mean it that way. Commissioner Goldman was sworn in at the last meeting, so I'm trying to help as a new commissioner. So my apologies if it's not.
I am still learning, so thank you.
Do we need to read the resolution number into the record to make that motion?
Just the number and the title with your amendment.
Yes, that number and then that kind of that
Okay, so I would like to make a motion to affirm Resolution 24-656, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision as application number D4876 with the ability to waive the 6 months.
Sorry to interrupt. I believe that may be a different appeal.
Oh.
The second appeal.
Sorry, I pointed to the wrong one.
We can just amend that with 4869, if you accept that new number.
You accept that?
Yes,
Okay.
yes.
And do we have a second?
Second.
Commissioner Paris seconds. Any further discussion? Seeing none, may we have a roll call, please?
Commissioner Goldman,
Aye.
Commissioner Kirby's,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Vice Chair Rory,
Aye.
Chair Bass.
Aye. The motion carries. Let's see here. Something I was supposed to read. So if the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. And then this will move us on to our second appeal. Does the commission need a break at this point in time, or shall we move on? We'll take a 5-minute break. Back now. Let's move on to our next appeal. The instructions are the same, if I can get them right this time. So we will move forward with our appeal for D4876, which is at 8558 Holloway Drive, apartment 102B. Do we have a staff report?
We sure do. My name is Kellen Martz, legal counsel to the Rent Stabilization Commission. Again, this is a staff report for D-4876. In this case, you have two issues before you, another MAR, maximum allowable rent matter, and whether there had been a substantial reduction in the housing services that warranted a rent decrease under our laws. The tenant in this case has lived at this property since 2018. Her initial request was for a MAR determination and stated in her application that the landlord had failed to register the property with the city and that housing services had been substantially reduced without a corresponding decrease in rent. The hearing examiner found that the MAR was $2,600, which was the initial rent when the tenant moved in, as the landlord had failed to properly re-register the unit. The hearing examiner also found that there was a substantial reduction in services that warranted a $69.50 rent reduction, and this was applicable to all tenants in the building because these were common area services. The exception to this is one apartment did waive their right to this rent reduction. The landlord appeals in this case, contesting both the MAR determination and the reduction of housing services rent reduction. The landlord states that the determination was contrary to provisions of the Rent Stabilization Ordinance or state law. The landlord argues in the appeal tonight that they are in compliance with the Rent Stabilization Ordinance, specifically with the on-site property manager, stating that they are in compliance with the RSO, which requires 4 hours of property management, and they have someone there from 6 to 10 p.m. Monday through Friday. They also state that since the beginning of 2024, there are additional management services available by phone from 8 a.m. to 5 p.m. Monday through Friday. The landlord further argues that as to the intercom issue, that this has been functional since the end of 2023 and that there is updated information in the intercom system. Staff in this matter recommends that the commission affirm the hearing examiner's decision. You as the commission have the power to affirm, modify, remand, or reverse the decision by the hearing examiner, and this concludes my report.
Thank you. And do we have any questions for staff at this time? Seeing none, I do have a question for our secretary. As far as public comment goes, see that there are other tenants in this building who have signed up to be public comments. Do they speak as part of the appeal, or do we hear their comments separately?
As part of the appeal.
So we would hear public comment now and then go to the appeal, or would we do that after the parties have spoken?
I'll defer to legal counsel.
I asked the wrong person, I'm sorry.
No, Roger's the right person. I'm just backup.
Okay.
In this case, the public comment would come prior to opening the hearing for the parties to state their case. So they would go first as public comment, and then you would open the hearing for both parties to state their 5 minutes.
And even though those parties are affected by the decision?
That is correct. Because they're not appealing parties, they are, I don't mean this in a derogatory manner, the same value as someone that walked in off the street that has no connection to the case.
Okay, so that would mean we are at the point for public comment at this point in time, and can I ask our secretary to please call on public comments? And when you speak, please state, it's obvious as an affected party where you live, but for the record, could you please state your name and city of residence, and you'll have 3 minutes to speak.
Okay, my name is Diana Caspi.
Can you bring this in?
Sorry.
Yeah.
My name is Diana Caspi. I live at 8558 Holloway Drive. I'm at apartment 106A. The reason I'm here instead of Kathleen is because she accepted a payout and moved out of the building. She's no longer residing in the building. We wanted to make sure that all the renters that are left over in the building are aware that you will be hearing that they are providing managerial services between 6 and 10 p.m., which is not true. I have over 100 pictures that we've taken that shows that she's not there. Those pictures are all dated and time-stamped. She shows up from time to time after 8:30 or something, whenever she wants to show up, and She does nothing that has to do with any managerial services. She doesn't even walk around to see what's happening. We're constantly in touch, the whole building, with the actual management team that's available over the phone. And we're constantly telling them the trash is full, they didn't clean it, the people that's coming are using gas things, they shouldn't be using it, it's illegal. They need to pay attention to this, the garage lights are not working, and so on. So she's not aware of what is happening in the building at all. So not only that, I've been living in this building since '95, and we've had a manager on site between 9 to 5, and it states in our leases that we have to have these services given to us as a part of living in this building. So we wanted to make sure that you guys are aware of this when you're making a decision, whether they made the correct decision or not with this hearing.
Thank you very much. And I believe we have one other public comment. Thank you. One other public comment via Zoom.
They're not in attendance.
Okay. There are no other public comments at this time? Seeing none, we will move on, and the landlord appealed here, and so the landlord will be entitled to 5 minutes, which they can split however they choose. Just let us know at the beginning, and the floor is yours. Again, your name and city of residence and how you want to split your time.
Hello, thank you. Thank you for your time. My name is Alex Galicia from Los Angeles, California. I'm a senior property manager for Starkwood, which is the property management that manages 8558 Holloway Drive.
And how would you?
I think I would.
Oh, go ahead. Go ahead.
I think I would do a split. I'm not sure. Like basically, the information that I have is very simple. It's exactly what he just told you guys. We have an on-site manager on the premises. She's there from 6 o'clock to 10 p.m. Full services for management are offered from 8 a.m. to 5 p.m. Monday through Friday. We have not neglected any type of request from any resident. We submitted all that information on the hearing that Kathleen Smith, which was the former resident manager that no longer lives in the property, that she's not here today to appeal, that created this appeal. We think that was maybe hurt that she was not longer working for the management. We took over in December 2023. So we've been managing this property for the last 9 months. When we took over, all these issues were already there. Whatever she was claiming that they were not getting on services, they were already happening in the property. She was manager for a year before we took over, and none of the services were taken care of at that time. We are the ones that came over and started doing everything that they were requesting, the residents were requesting to us. The intercom has been working. Actually, Ms. Caspi, she's one of my witnesses that she called the office and asked for her intercom to be fixed because the on-site manager that she had never fixed it for her. And in January, we fixed it for her. So that's part of what the appeal was, that the intercom has been working. And when we went to the appeal, I make sure that I explained that to the hearing advisor. And I don't know why that determined that the intercom wasn't working. And lastly, maintenance and any type of complaints and information that they need to submit, they can send it to our office. We're available again Monday to Friday from 8 a.m. to 5 p.m. and Monday through Friday, the on-site manager from 6 p.m. to 10 p.m. I'm sorry.
Thank you. Is that what you have for us?
Yeah.
Okay. It's my understanding, and Roger, correct me that the tenant is not here?
That's correct.
Okay. So you do have the option of dividing your time, but there's no one to rebut, so there's nothing to really divide. So I'm going to ask the commission if they have questions at this time. Vice Chair Rory.
Thank you for coming tonight. On the MAR determination of 2,600, you're not disputing that it's 2,600, correct? Okay.
Not at all. Yeah.
Okay. And then do you have an understanding, this might have been before your representative's company took over, but in June through November of last year, it looks like the tenant paid less in rent. Do you have an understanding as to why that occurred?
I believe was because she took the on-site management position for that property. And that's what the agreement that she had from the previous owner. We are new owners and management company effective December 6, 2023.
Okay. And this tenant was the previous on-site manager?
She was the previous on-site manager, and she was fully aware that her unit was not registered.
I see. Okay, I had missed that detail. I'm glad I asked.
Fully aware.
Thank you. Any other questions? Seeing none, thank you very much.
Is that it? Oh,
Yeah,
thank you. Thank you so much for your time.
thank you. I have a question for staff, based on what we just heard, that the tenant is no longer in the building. Would that nullify the appeal when it comes to the MAR? Since it doesn't, there's
Can you
no-
repeat your question? Sorry.
So if the tenant doesn't live there anymore, obviously the rent reduction that's applied to the rest of the units still applies. They're not penalized because the tenant who filed.
Correct. The appeal goes forward as is.
And when it comes to the appeal, any question, I'm trying to see it on the MAR here. The MAR was the MAR appealed? I don't remember that being. The termination of the MAR was not appealed. Does that know if that?
I think it was
Give me 1 second.
one of our questions to be determined.
Yeah. I'm just looking at the appeal form.
The landlord did appeal the MAR. So if you look at the appeal, how these are handled at the staff level kind of depends. If they just say the determination is contrary to law, typically we look at both or all of the issues.
Okay,
But in their written explanation, it doesn't speak to the MAR.
okay. I just wondered if that still applied since that particular tenant is not there. That was what my question was. Do we make a finding on that even though that tenant isn't?
Yes, yeah, you would
Okay.
make the finding in full.
Okay, thank you. That was a process question, not in any way a position on anything. Any questions or anyone would like to start deliberation?
I have a question.
Commissioner Paris.
If the MAR was appealed, when when was the appeal made? Was it prior to the current landlord taking
I would have to look at the specific dates where everyone moved in and out. But who the landlord is doesn't technically matter. They take over the previous landlord's issues, basically.
Commissioner Paris, it says that the application was filed on March 10th of this year and all the proceedings have happened since then, so I believe it was the current landlord.
Thank you.
Anyone like to start deliberation?
I'll start deliberations.
Okay.
Really, when I read this case, the only thing that popped in my mind was, especially after reading the glowing review of the current manager by the landlord. The only thing I thought about that was in this case that was confusing to me was in situations where landlords add services or things like that nature. Let's say everyone gets free cable from now on. I've owned the building for the last year, and we're 6 months into my ownership, and I decided I'm going to start giving free cable to everybody. If I ever take that away, that's a reduction in services. So I'm glued to that for the rest of my tenure there as, or actually me and future landlords. In this case, you know, me as a tenant, my hours of having a manager on site would be much more beneficial to me if they were 6 to 10 at night. And because one of the people opted out of this appeal, it just raised the question in my mind. I wonder what happens when the landlord takes that 6 to 10 p.m. services away and goes back to the 9 to 5, which I do believe they have to if they want to restore the rent reduction. What does that tenant get to potentially file a hearing or ask for a hearing for a service reduction if that tenant felt that was a value that they were losing?
Yes, I mean, it's a hypothetical and we don't want to prejudice it, but yes, they could file under those facts.
Yeah, that's the one thing I do not like about our very strict, and I mean, glad it's a strong rent control ordinance, is because of those times over the years that I've seen where a tenant or a landlord has added a service, you know, or tried to do a good thing and try to improve some services, and then it all goes bad when, you know, that cable company stops servicing this area or they stop getting that great deal. But I think the facts in this case are that the lease, to me, what it was it all really dependent on that lease. I think that the hearing examiner weighed a lot on the fact that the lease said 9 to 5, because you can, as the landlord was trying to do, in many cases, you can try to provide same or like services that would replace the services that you're changing. But in this case, you know, the landlord or the tenants fell back on that lease, and it sounds like that they were getting a lot of value from the 9 to 5 service that was laid out in the hearing. So I would choose to affirm the hearing examiner's decision in this case. Personally, I think the $69 is a little high, but you know, that's not for me to question because it does look like there was a lot of description on what services were offered. I think it is difficult. The landlord had a difficult case to try to balance those benefits from the previous to the benefits that they claim or the tenants will get from this new service, but or this new form of service, because they were going against the property manager who actually did those services. So she was quite aware of what services were provided. So I think the hearing examiner made the right decision on both the MAR, of course, but also on the 2 reductions. And I would just encourage the landlord that if they feel that they have fixed the remote, the radio service, the intercom, thank you, that's what I'm looking for, the intercom, that they need to file a compliance determination with the city so that you can have a decision made and that will be restored, the $6. That's all I have.
Thank you. Who would like to go next?
I guess I think this appeal is pretty straightforward, but it spurred a question for me, and maybe it's just I'm a little confused. In my mind, there's a difference between having the on-site manager and then having a property management company that you can call. And I just kind of want to make sure my understanding is correct. You need to have a property management company that you can call from, I don't know exactly what hours are, but maybe legal counsel can explain. It's like 9 to 5 or, you know, over the majority of the day. And then if you're a building that has over a certain number of units, I saw it earlier, but I forget, I think it might be 16, if that's correct. Then you need to have an on-site manager, and that on-site manager has to be available on-site on the premises for at least 4 hours a day. But those are 2 different requirements in play. Is that right?
Not quite. The only requirement is to have an on-site manager. So theoretically, I think this is a large building. The owner could hire one person that's a tenant to be a resident manager there under the hours required by the code. And there doesn't have to be another office elsewhere, so long as they're able to keep up with the services that are required.
Okay. And it's 4 hours of on-site management per day is what the code currently requires?
That is correct. And for all commissioners, I just want to, some of you have alluded to it, some of you know it, but there are two ways that this is looked at. One is whether they're meeting our code. That's simply the 4-hour requirement. And then as Commissioner Kirby has alluded to, there's also the reduction services. So that's what staff is recommending here. And what we found is that even though they may be hitting the bare minimum of our RSO, there was a housing service provided originally at the bigger amount of hours and the bigger services. That's a reduction of services, not a specific code section that they're breaking. So there are two ways that they could be in trouble here, and staff is stating that it is that second explanation.
Okay. Well, then I'll just continue because maybe we go into my deliberation, but I think what I would say is it sounds like I would be in favor of a motion to affirm. It sounds like this is an issue where the MAR was properly determined at 2,600, but for this particular unit, there was no balance that was actually overpaid. So that you know, no money is really going to like shift or change hands here. It's just going to be the new MAR is going to be set at 2,600, which seems right. And then in terms of the reduction in services, I would affirm on that as well. What I would say for the manager who's here tonight, it sounds like you were here, you heard the public comment. It sounds like other issues going on with the building, and that maybe some folks still aren't quite happy with the new system for the on-site manager, and that was a theme that I picked up in reading these materials. Obviously, I'm not there, and this is not a back and forth. I'm just telling you my perception. So, you know, especially with your appeal and you coming here tonight, it sounds like you guys definitely want to make this building spick and span as best as it can be. I would encourage the landlord and its representatives to make sure that the on-site manager issue is looked into or being addressed currently, and that someone's there, because it's sounding like that may or may not be the case. But for the particular issues before us tonight, I'm kind of inclined to affirm.
And, yeah, please, Commissioner Goldman.
I agree with my colleagues. I'm inclined to affirm on both as well.
Commissioner McCafferty?
Yeah, this one seems pretty straightforward and, yeah, inclined to affirm.
Commissioner Paris, before I go?
Inclined to affirm as well.
Okay. So a lot's been said, and I appreciate it. I'm going to weigh in just a little bit here. Yeah, the MAR is, for me, inconsequential because the tenant doesn't live there anymore. So we're going to determine the MAR, but no one lives there so that one's kind of irrelevant to me. On the intercom, if it's fixed, know that we can't hear testimony as to whether or not the intercom is fixed here. We just have to determine if the hearing examiner erred in making that decision. So if it has been fixed, there is a process, and staff can help you with this, called a compliance determination, where something you could file tomorrow, and then that decision will be made by a hearing examiner. And were you not to like that compliance decision, you could certainly appeal it, as could the tenants. As to the on-site manager, this one's important to me because I just explained my thinking, and that is oftentimes I believe landlords think that rent reductions are penalties, and they're not. So when you enter, the way I see it, when you enter into an agreement with landlord and tenant, you agree to an agreement. You have an agreement. This is what I'm going to get for this amount of money. And if that service that you're being provided, whether it be in this case, an on-site manager, if it's carpet in the building, whatever it might be, intercom, if that's reduced, then then the rent has to be reduced in a comparable way. And some landlords and tenants work this out and they say, hey, you know, I'm going to get rid of this particular service. We're going to reduce your rent by this amount. And it never goes to the city because it's just, they figured it out. But in this case, the tenants are saying that they wanted an on-site manager for those, you know, during the day, and that they're not getting that service. The hearing examiner agreed with that and says that the rent needs to be reduced in that same amount. It might be in the landlord's interest to say, yeah, okay, we don't want to have a landlord during that period of time, and it is worth it to us not to have that, and all the tenants get this reduction of this amount. That might be a business decision they make, and that therefore the tenants are being compensated in a reduced rent, and the landlord can make the business decision that they want to make. Obviously, there are health and habitability, a hard word for me, issues that the landlord can't just like, I'm not going to do this, and it creates an unsafe environment. But in one like this, the landlord could just decide that's what they want to do. And the hearing examiner decided that there was a value to that of, what was it, around $69? And I see nothing in the record here that shows that the hearing examiner made a wrong determination. So I wanted to give that background because from the appeal, it looks like the landlord is really invested in creating a good environment here. And I hope that that's the case. And I hope that this is a good relationship with the tenants and landlord going forward. But before voting to affirm with the rest of you, I wanted to state that it's not in any way a penalty. It's more of a compensation for the service. So do we have a motion?
I would like to make a motion to affirm resolution number 24656, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision as to application number D4876.
Second.
We have a motion and a second. May we please have a roll call?
Commissioner Goldman,
Aye.
Commissioner Kirpies,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Vice Chair Lori,
Aye.
Chair Bass.
Aye. The motion carries. If the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the Services menu. That ends our appeals for this evening. Number 9 is unfinished business, and I don't believe we have any. As I look at my agenda, we don't. Number 10 is items from staff. Do we have anything this evening?
No items from staff at this time. Thank you.
Thank you. Number 11 is public comment. Do we have any public comment?
No public comment at this time.
Thank you. And item 12, items from commissioners. It is a quiet bunch, but thank you all for your service. I'll say that. With nothing else, this meeting is adjourned to the next regularly scheduled meeting of the Rent Stabilization Commission to be held on, I don't have that in front of me here. October 24th. In the West Hollywood Park Public Meeting Room, Council Chambers, this room. Thank you. Have a good night.